Hello and welcome to this press conference held here in The Hague at the Hague Humanity Hub. My name is Janet Anderson and I'm moderating this event. I'm just going to run through what will happen for the next half an hour or so and then give you the chance to ask some questions yourself. So first of all, we're going to hear details of the submission, which I think you can see lots of copies of, a communication which has been made to the Office of the Prosecutor of the ICC. We're going to hear directly from one of the gentlemen who is behind this. This is Dr. Johan van der Lanotte, former Deputy Prime Minister of Belgium and a reputed former Professor of International Human Rights Law. He's going to be describing what this communication is about and why. Then we're going to run a couple of small videos from other people who've been connected to this communication, and then we will open for some questions. So, Johan, over to you.
Thank you. Good morning, everyone. So indeed, on 9 February this year, we have submitted a communication to the Office of the Prosecutor of the ICC. And when I say we have submitted, that is our lawyer's office, Van Steenbrugge, where you see the picture there with my colleague Johan Heijmans and myself on behalf of some 40 victims that we are mandated by. Second signatory is the Belgian-based NGO Turkey Tribunal, on behalf of which the President, Mark Bossuit, Professor, former President of the Constitutional Court in Belgium, and former President of the Human Rights Commission, has signed the communication also. And the third signatory is MEDEL, Magistrat pour la démocratie et la liberté. That's an organization of judges and prosecutors from 23 organizations, 16 countries, representing around 18,000 magistrates, on behalf of which the President, Mr. Judge Maria Rosaria Guglielmi, has signed. So we introduced three instances this communication. It was our original intention to organize this press conference on the same day, 9 February. However, this was a period of national mourning in Turkey, and we decided it was not appropriate to organize it at that moment. And we postponed it for a month as of respect for the victims, and I want to take this occasion to express our solidarity with the victims of the earthquake, and as a lot of Belgian persons and NGOs did, we meanwhile also donated to the Belgian Red Cross to help the victims. So we introduced this communication. What are the essential elements that are needed to analyze acts as crimes against humanity in the context of the Rome Statute? First of all, the crimes must be in the list. There is a list. The Rome Statute is a convention, is a treaty, and in Article 7 they enumerate the crimes that are considered crimes against humanity. However, they only come under the jurisdiction of the ICC if they are committed as a part, and I'm citing, of a widespread or systematic attack against the civilian population whereby the crimes were committed pursuant to or in furtherance of a state policy to commit such an attack. Simply said, when a policeman tortures a person, it is a crime against humanity, but ICC will have no jurisdiction unless it is part of a global attack, the systematic, widespread action that is, in our case, supported by the state. Then the ICC has jurisdiction. So that's what we have to prove. Which are the crimes? Oh, I pushed the wrong button, sorry. Here. Which are the crimes that we documented in our communication? First, torture. Second, enforced disappearance, people abducted, kept away from protection of the law for a certain period, imprisonment in violation of fundamental rules of international law, and persecution. That are the 4 crimes that we have documented, and who are part of a widespread or systematic attack. First, torture. The communication includes 463 individual statements of torture, relating to some 800 identified or identifiable persons. That are the people who spoke up under the discretion rule of the ICC, which means that these testimonies at this stage will not be transferred to the Turkish government. That was the condition for most of the people to speak up. And I must clearly say that a lot of people still are hesitant to speak up, which we understand. And that's also in the context. We have 460 statements, which we find a large number, but the Turkish Human Rights Association between 2003 and 2021 received in average 1,460 complaints per year that were related to torture. It's immense, and it is continuing. Secondly, enforced disappearance. And you see the picture here of Selahattin Gülen, a nephew of Mr. Gülen himself, who was abducted also. The communication documents 59 cases of extraterritorial or domestic enforced disappearance. Extraterritorial means people are apprehended and abducted from a foreign country to Turkey. Domestic enforced disappearance, people disappear in Turkey and in some cases show up afterwards in a police station. In some cases, until today, after years, they never show up and most probably were killed. And all these 59 are related to 109 persons. Third kind of crime, which is the most numerous, is imprisonment in violation of fundamental rules of international law. First, we have the official statistics about that, where investigation was started for membership of a terrorist organization of more than 2 million people. More than 2 million people were investigated, put on trial a bit more than 500,000, and as members of a terrorist organization, 270,000. 270,000, and it is important to mention, only can be condemned if they have a hierarchical position in the organization. So this means that according to official statistics, 270,000 people have a hierarchical position in a terrorist organization in one country. It's absurd. It's absurd. But it is the official statistical, and let's say that with some exceptions, the minimum punishment is 6 years and 3 months. Some have lifelong sentences, but that's the minimum, the 6 years and 3 months. Our communication, oh, sorry, I forgot to push, but here it is. Our communication has documented 1,789 collective actions of police and prosecutors to apprehend people, to put them in detention, to put them in jail imprisonment, and is related to 51,000 persons. But next to that, there is numerous decisions of the European Court of Human Rights and of the UN Working Group on Arbitrary Detention, who clearly confirm a breach of basic human rights, most of all Article 5, 6 of European Convention, fair trial, and the absence of a clear legislation on what terrorism exactly is. Prosecutions are continuing, and even in a more arbitrary way. In November of last year, we got information and documents, so it's not only hearsay, but it's documents of people who were apprehended and who were detained for weeks, some for months, because they were visiting the graves or attending the funerals of deceased individuals who were seen as opponents of the system. People went to the cemetery paid their respect to some person who was allegedly a member of the Gulen movement, and that was enough to be put for weeks in jail. And the system goes on and goes on. Fourth is the persecution. The essential about persecution in the Rome Statute is that it is a violation or limitation of fundamental human rights, but in a very discriminatory way. Because people belong to the Kurdish movement, because people belong to the Gulen movement, because people belong to the opposition, they are targeted. So you need to indicate the violation of fundamental rights, and you need to indicate that it's discriminatory. What we have is dismissal of nearly 130 public servants, 130,000, excuse me. Teachers, 20,000 who lost their license to teach, who were teaching in a private institution, cannot teach anymore. 234 persons' passport was withdrawn or cancelled, or no ID was given. 162 schools outside Turkey were closed with a violation of fundamental rights of the teachers, expulsion, prosecution, abduction. And of course, we could say this is not the severe crimes, you could say. I will ask a question, it's a rhetoric question. Is a drop of water that you let fall on the head of someone a violent act? Everyone will say no. However, there is a method of torture, not in Turkey, it is an older method, where they fix a person on a table and every 6 seconds, 5 seconds, 7 seconds, they let fall a drop of water. After 3 days, the person is dead. It's the continuous effect of each time violating, in our case, human rights. So these people that we're talking about, they are losing their jobs. Their children cannot register at schools. They cannot enroll in university. They are not giving the allocation for children. They are not getting their pension. In their social security system, they are mentioned that they were dismissed, so no, even not private companies are recruiting them. They don't get ID for their children. They don't get, if abroad, a nationality for their children. And so we can go on. We listed in one of the annexes, Annex 7, we listed 40 ways to deprive these persons from fundamental rights, which are cumulative. And that's why we are saying that this persecution is not killing most of them, but is condemning them to a social death. It's a social death, and that's the atrocity of this persecution. As we said, these crimes must be part of the attack. I will not go into detail on this legal, but it's a strictly legal definition. What is the attack? It's about multiple commission of acts, a course of conduct, directed against a specific civil population, pursuant to a state policy. It is planned, it is systematic, so non-accidental repetition, and is linked between each other. We have documented that, I think, in a very convincing way in our communication, but I will not take your time with explaining this strictly legal elements. That's the attack. So, next is the cases for individual criminal responsibility, because that's not the same. For these 200,000 people who are victims, we cannot put all the crimes documented in the communication. They cannot all be judged by the ICC. They are important to prove the attack. It's important, it's needed, it's necessary, it's a requirement. But only of these 200,000 and more victims, only the crimes committed or started in a state that ratified the Rome Statute can be judged by the ICC. So you have the global attack, which is needed to give authority of jurisdiction to the ICC, and you have the individual cases, but only those committed in a party state. And that is why the reason for the crimes that we have submitted for individual responsibility until now, crimes against alleged members of the Kurdish movement who are suffering from torture, enforced disappearance and imprisonments, which we documented, and crimes against opponents of the regime, most of all imprisonment, cannot lead to individual criminal procedure before the ICC, because these facts, nearly all were committed in Turkey or in non-party states. So the 1,300 victims that we bring under the individual criminal responsibility procedure of the ICC are all persons allegedly linked to the Gulen movement. That's the reason. It's not our choice. It's the facts as it are now. What are the cases? 17 cases of enforced disappearance in 8 party states. The closure of 73 schools in 13 parties with dismissal, persecution, abduction, expulsion of 522 teachers and their families, so related to more than 1,000 people. The discriminatory withdrawal of passport, discriminatory non-extension of passport, discriminatory non-issuance of ID cards, even from newborn children, which means no nationality, no registration, not possibility to go to school. This means also no traveling possibility. People who are working abroad cannot get their permit, their working permit anymore, and so on. In 29 states related to 206 persons. Until now, 1,300 persons involved as victims can be brought under the individual responsibility procedure in the ICC. That's for now. We are sure that once the investigation really starts, the number of persons who will speak up will clearly be higher. There is still, as I said, there is a fear, it's logic, and there is hesitation to speak, but we are sure this will still grow. And anyhow, 13 persons under the individual procedure, knowing that there are 200,000 and more victims, is already a substantial element. Question, of course, Turkey is not a party to the ICC. How then can the ICC be competent? That's a question often asked. Indeed, the court already in 2019, in the case of the Rohingya, whereby Myanmar expulsed the Myanmar to Bangladesh, the court, ICC, decided they had jurisdiction, although Myanmar is not a party state. Myanmar did not recognize the ICC. However, the fact that at least the consequences of this expulsion and so the discrimination of these people continued in Bangladesh, not because of Bangladesh, but because of Myanmar, they said we have jurisdiction. It's a very important decision. It's not the only one, but this means that if, for instance, someone is abducted in a country and brought to Turkey, the fact it started and already was and sometimes completed, all the crimes were completed in that country, gives the ICC jurisdiction, not because that country did something wrong, but because officials from the Turkish regime were responsible for this enforced disappearance, even if, for instance, like in the Kenya case that we submitted, the court decided that the person could not be extradited. However, the Secret Service, together most probably with the Secret Service of Kenya, made such that the person was abducted, was more than 30 days tortured, and finally showed up, was presented in Turkey. We have the same with this, for instance, the passports. We have embassies of Turkish embassies abroad. When their discriminatory acts are committed, it is under the responsibility of the officials of Turkey, but it's on the territory of the state and so on. And in this system, we have 1,300 victims in 45 party states. for which ICC has territorial jurisdiction and for which officials of the Turkish officials, high-ranking officials, and officials means administrative or political responsible persons of the Turkish states are responsible. All these crimes have been described in a detailed way. You see our 4,000 pages communication with 400 who is describing everything, and then 3,600 documentation, annexes, testimonies, and so on. And only crimes that are really corresponding to this criteria were kept. We selected quite intensively so that there would not be a legal discussion. Why we think the ICC should act? Why we submit that? Because the prosecutor has clear discretionary power to say yes or no, we will work on it. And of course, the whole communication must be legally correct. We have submitted our communication to 4 or 5 international experts. We have worked hard on it. We have some expertise in-house also. We think legally everything is as it should be. But still, then is the question, is it important enough? The gravity requirement. We think it is, and that's why we went to the ICC. First of all, it's about 200,000 victims. If I may not be cynical, unfortunately, it is not 200 persons who are physically killed, but 200,000 persons who are in a situation of social death, with all rights possible in a society violated. It's a broad geographical scope. It's a long period of time. A lot of judicial decisions have not been respected deliberately. European Court, United Nations Committee on Human Rights, national courts, even Turkish courts in some cases, and each time a decision of any court was not what the government wanted, it was denied. I have been reading this nearly 500 testimonies of torture, all of them. It's a cruel lecture. We are now here saying for 400 witnesses, 800 victims, it's very impersonal. When you read it, you feel the cruelty of it. And even children, not in torture, but even the children are not saved. They do not get identity cards, they do not get possibility to go to school, they are separated from their parents. Children who are terminally dead, the mother is not allowed to join them. And most of all, perhaps, the crimes must be considered as deliberately and proudly disdaining the basic principles of international law, which the non-refoulement is one of them. You see here this picture of a press conference by President Erdogan. And he's proudly showing the picture of Mr. Inandi. Mr. Inandi was abducted in Kyrgyzstan. He was tortured for 37 days and then was shown to the public. As you show the hunter who shows who he has killed. Mr. Inandi luckily was not killed. But if you look well, and some medical doctors looked well, you see that he is holding his hand this way. He is supporting with his right hand, he is supporting his left hand, or the contrary. I cannot say because it's a picture, so we don't know what left and right. He's supporting, and doctors went, and you see that his hand is swollen. And immediately they say, Mr. Erdogan is showing that he had tortured him. And he's proud to say, we can abduct from everywhere in the world, we can torture you, and no one will punish me. This is the most horrible picture of disdain of everything about criminal responsibility that you can think. Afterwards, it was indeed confirmed that in the torture he had broken his arm in 3 places and he had surgery afterwards. But showing, I am capable of abducting and torture, and no one can touch me. That's what's shown on this picture. And the gravity of that is immense. We are all confronted with the war in Russia, and we know that ICC is now investigating in this war because it's a war against the people of Ukraine, and it is a war against most elementary principles of international law. The crimes committed by Turkish officials against opponents of the regimes are another type of war, that's clear. Condemning the opponent to torture, to imprisonment, and as I said, to a social death. Most of the persons are not killed, lucky enough. But it's condemning them to a social death. And I would take the occasion to cite something that the economy minister of that time, Mr. Nihat Zeybeki, said about the Gülen movement specifically. He said, "We will put them into such holes," he wants to say, jails, "for punishment that they won't even be able to see the Son of God as long as they breathe. They will not see the light of day. They will not hear a human voice. They will beg for death, saying just kill us." That's what it is about, the social death of these people. The drop each time until they beg, just kill us. And so, after more than 5 years, it is clear that no national judiciary, no international judiciary can act except ICC. It's the only way to punish these crimes in Turkey and abroad, and to prevent that the same crimes happen again, which is one of the clear tasks why the ICC was created, and to protect these basic elements of the international legal order. And that's why the international community is linked to this case. It's broader than the situation in Turkey. It is linked to the general international order. There are persons who are responsible for this act. I'm sorry. The persons who are responsible for this act, they knew that what they did was against all basic rules. They knew, but were certain about their impunity. No one would be proudly showing that he abducted someone and even clearly expose the torture case if he was not sure about his impunity. The ICC was created to hold his impunity, and that's why we call on the ICC prosecutor to take up this case and ensure that no individual, not even if he serves as a high official of a NATO ally of the West, can be considered above the law. In the past, we know that ICC concentrated mostly on non-European countries, often failed states. And Turkey is not a failed state as such, but it is a failed state as far as the rule of law is concerned, and it is a failed state as far as the criminal procedures against officials committing crimes against humanity are concerned. There is a tendency to underestimate crimes committed in Western countries, thinking it is accidental, it is under judicial control. It is not that bad. It is that bad. It is not accidental. It is not under any national or international judicial control. And that's why the initiators of the communication could not imagine that the gravity of the situation would not be recognized by the prosecutor. From the beginning, we had some supporters, but who was helping us. I give the floor to Janet because we have some videos and introduce to her. Afterwards, you can ask questions, of course.
Thank you. I'm sure there will be a number of questions that people will want to ask, so Johan will come back. For running videos, just to check, should I use this or you will go ahead? Let me just introduce the first one. The first person we're going to hear from, they're just a couple of short videos, is Mark Bosshout. Has previously explained he's the chair of the board of the NGO Turkey Tribunal, former president of the Belgian Constitutional Court, and former president of the UN Human Rights Commission. So we're going to hear from Mark us out first.
Today, a communication has been submitted to the prosecutor of the International Criminal Court in The Hague. That communication relates to crimes against humanity committed in Turkey. The communication has been submitted by the Turkey Tribunal, a Belgian non-governmental organization, assisted in this by VS Advocaten, a Belgian law firm, acting on behalf of some 30 victims of those crimes. The communication has also been submitted on behalf of MEDEL, European Magistrates for Democracy and Freedom, a European organization of judges and prosecutors. The communication is extremely well documented, as it is based on the proceedings of the Turkey Tribunal, which was held in Geneva in September 2021. They were and they are committed under the responsibility of the highest officials of the Turkish Republic. Those crimes took place after the failed coup d'etat of 15 July 2016. The submission of this communication should not be perceived as an act hostile against the Turkish Republic. Neither is it an action in support of those that were involved in that coup d'etat. It is an action in support of those, and there are many, that are victims of those gross human rights violations. The Turkey Tribunal hopes that the proceedings of the International Criminal Court will establish the responsibility of those that committed these crimes against humanity. I thank you.
And our next video is from a US citizen who's well known as a big basketball star there and a famous human rights activist. That's Enis Kanter Freedom.
Hello everybody, it's Enis Freedom, an NBA player and human rights activist, and I just wanted to say I applaud the introduction of the communication to International Criminal Court concerning crimes against humanity committed by high-ranking officials to the Turkish regime. I experienced personally how outrageous the regime was acting against any person opposing it. Torture, abduction, imprisonments were massively committed. A whole group of people were condemned to a civil death. Crimes against humanity were committed and stayed unpunished until now. That is why the communication to the ICC is so important. Sadly enough, such crimes committed by strong Western countries never were prosecuted. Criminal responsibility for crimes against humanity, however, cannot be selective. The introduction of the communication is a strong signal of the wish of so many people that impunity cannot be tolerated. I hope the ICC will breach the impunity. That is why it was created. That is what it should now realize towards the Turkish officials. Thank you so much.
And the third short video is from Doğan Özgürün, Turkish exile journalist, editor-in-chief of InfoTurk news agency, currently based in Brussels.
Ben ve eşim İnci Tuğsavul 1971 askeri darbesinden bu yana sürgün Türk gazetecileriyiz. 60'lı yıllarda İstanbul'da Akşam Gazetesi'ni, ardından da Ant Dergisi ve yayınlarını yönetmiştik. Yayınladığımız yazılar ve kitaplar nedeniyle hakkımızda 300 yılı aşkın hapis istenen basın davaları ve silahlı kuvvetlerin tehditleri nedeniyle Türkiye'yi terk etmek zorunda kaldık. Yarım yüzyıldan beri Brüksel'de Türkiye'deki insan hakları ihlalleri ve siyasi sürgünlere yönelik baskılar hakkında dünya kamuoyunu bilgilendiren InfoTurk basın ajansını yönetiyoruz. Yayınlarımız ve Türkiye'deki baskılara karşı mücadelemiz nedeniyle 1982 yılında sürgündeki 200 Türkiye'li muhalifle birlikte Türk vatandaşlığından çıkartılarak vatansız yapıldık. Halen Belçika vatandaşıyız. Ancak yıllardan beri Türkiye Büyükelçiliği'nin ve onun emrindeki kurumların tehdit ve saldırılarına hedef oluyoruz. Hak ihlalleri nedeniyle Türk mahkemelerinde açılan davalar ne yazık ki sonuç vermiyor. Avrupa İnsan Hakları Mahkemesi'nin kararları da Türk devleti tarafından dikkate bile alınmıyor. Baskı kurbanları hala zindanlarda tutuluyor. Uluslararası Ceza Mahkemesi nezdinde açılan bu davanın bu nedenle tamamen yerinde olduğuna inanıyorum ve de Türkiye'nin demokratikleşmesine büyük katkı sağlayacağını umuyorum.
Great. Can I invite you back up, please, Johan? So, if you have any questions, now is an opportunity to ask them. There's also the opportunity to set up some individual interviews if you'd like to straight after this. Anybody? Go ahead.
Hi, Danny Kemp from the. Danny Kemp from the AFP, Agence France Presse news agency. You mentioned the gravity of the crimes here. Obviously, you know, as you mentioned as well, we have a war going on in Ukraine, the various other situations being examined by the ICC. How realistic, how hopeful are you that this will actually be taken up by the ICC? I mean, obviously, I understand that you believe it should be, otherwise you wouldn't be doing this, but how realistic do you think it actually is that this will be taken up? Thank you.
Thank you for the question. It is indeed so that the war in Ukraine is taking a lot of energy, resources from the ICC. However, I also think that specific donations were made. I think even a new informatics system specifically for the Ukraine war has been set up in the ICC so that they can go on with their other business too. It's a question that everyone is asking himself. But I think that what happens in Ukraine is a physical war. It's a physical war, which is horrible. And that it was a very good thing that it finally, or quite immediately, was taken in account and was worked on. But the war that is happening against the opponents in Turkey is not the same physicality, but the effects are nearly the same. So and it's also about more than 200,000 people. I can only say I could not imagine that it would not be taken in account. And it's not because it's a NATO country that it should not be taken in account. But we know that ICC has a lot of work, has a lot of problems. A second element is that also the prosecutor, and I understand that, is taken in account. Can such an investigation lead to the definition of those who are responsible? That's the second element. I think in our communication we also have emphasized that. The specificity of this here is that the perpetrators are proud of it. It's very specific. So if an investigation is started, finding those who are responsible is not that difficult. if I can say. And also that is an element to put it on, because ICC needs also that they have investigations that lead to something. A lot of investigations did not lead to something. And so workload and a possible result are important, I understand. I think with what we presented, I think this introduction of this communication is probably one of the most elaborated communications to start with that ever has been made. And also the possibility of success is high. So now I do not want to think about the fact that it would not lead to an investigation, but I hope it is, of course. And that there is an impact of other cases, yeah, that's true.
Hi, Malikwa, Courthouse News Service. You indicated that there are a number of complaints that have been filed with the European Court of Human Rights, also related to similar issues. Can you say something about how much overlap there is between the crimes that you would like the ICC to look into and what is already being investigated by the Strasbourg Court, and whether or not you are concerned that the ICC may take the position that these allegations are already being investigated by another court and that it doesn't need to get involved with this particular set of circumstances? Thank you.
There is some overlap. If we are now thinking about the 270,000 people who are convicted for terrorism, so let's say don't take in account the numbers too closely. I think if we see all the procedures before the European Court that already have been decided, that's about 3,000–4,000 until now. So there are 265,000 who are not judged by the European Court. But the subject is also different. The European Court is deciding if the Turkish state violated human rights. The ICC is examining if persons, it's not the state, persons or individuals responsible for crimes. The judgment of the European Court are a kind of element of proof that it happened. Because when a state is violating a human right, it can be because it had an other opinion about it. It made a mistake. That is not necessarily a criminal responsibility of one person, of specific persons. If, however, repeatedly the European Court is deciding that there has a violation and even a deliberate violation, and there's no consequence given to such a decision, then we come much closer. And it's an element of proof that it is deliberately that human rights were violated and that it becomes a persecution. Human rights violations become a persecution when it is systematically done in a discriminatory way. Then we have persecution. So I think that they are complementary. They are not conflicting.
Thank you. Mike Corder from Associated Press. You talk about individual responsibility. Can you just elaborate, to be clear, who you think should be prosecuted?
A nasty question. It's a good question. It is very clear in the Rome Statute that it's not the people who introduce a communication who indicate the personal responsibility. It would be counterproductive to do that. The Office of the Prosecutor is very clear. It's their responsibility to do that. However, it must be made clear, we find, because we know that it is a concern of some effectiveness of a procedure, it must be clear that it is possible to identify those who are responsible. So we have, in one of the chapters, indicated, let's say, what are the possibilities of individual responsibility, and we were very prudent. But it is clear that some high officials, non-political officials, from the secret services, from the Mare Foundation, just to mention this, from Ministry of Foreign Affairs. And on the other hand, some important members of the government cannot deny that they are responsible and why they cannot deny. Because they proclaimed their responsibility proudly. Proudly they said, if we see the picture here of Mr. Nandi, we proudly say, we abducted someone, we tortured him, and here is the, and we will go on with it. So that's what we showed. So I cannot answer you with names, but I can just say that in our communications, we have enough elements that the prosecutor would identify the highest officials, administrative and political officials of the Turkish state who can be held responsible for it. Because it is very essential that when a prosecutor starts an investigation, he is sure that he will be able to identify those responsible. And that's what we clearly stated, that in our situation it's not the most difficult part.
Bünyamin taking Turkish minute. I think I will follow up on my colleague's question. What he wanted to ask, will Erdogan be charged by the International Criminal Court? What do you think? What is your opinion? Can a head of state of a NATO country be charged in such an investigation?
I will answer that as a hypothetical legal question. I'll answer you with another question. The ICC started an investigation for the Russian war crimes. Can the Russian president be prosecuted before the ICC? The answer to that question is the same legally as the question, can Mr. Erdogan be prosecuted before the ICC? They're both in the same situation. I must have the fact is that ICC started. So anyhow, this cannot be an argument not to start. But both President Erdogan and President Putin are in the same legal position. And the fact the president is from a state from the NATO or not does nowhere appear in the Rome Statute. And should, I tell you, should not play a role.
Another question. Do you think this procedure would take if it turns into an investigation and if it turns into a case?
It will take time. We're not concerned about that. We also know that, and sometimes therefore an investigation is important, that when an investigation is started, the office of the prosecutor also takes action towards the authorities of the states where the crimes were committed to act themselves. That's called the subsidiarity principle. So the ICC comes in when the countries themselves do not act. We have made a constatation that the countries do not act. But when the investigation is started, it is, let's say, a certain way of not officially working, but trying to push the countries to act themselves, which I find normal. It's not our discussion, our ambition is not that it is this or this judge who is deciding. It's the fact that the impunity stops. So if during this startup countries are pushed in an informal or formal way to act, we would welcome that. So time is not our biggest concern. This thing is going on for 7 years nearly. It's not the fact that it takes a bit of time. It's the fact that impunity is halted. That's the most important thing.
Hi, Typhon Balchik, de kanttekening. Maybe it's a stupid question, but I'm going to ask it also. You know, in Turkey, the earthquake happened, and more than 50,000 people died. Is that also a crime against humanity? Because the government was involved in all these construction of all these buildings, and they didn't follow any regulations. And is it possible that the Turkey Tribunal can add crimes committed by the government for letting thousands of people die?
I'm aware of the fact that in Turkey a lot of people now are indeed saying this also should be crimes against humanity. It's something that is done, but I think as a lawyer, I can only give answers in a well-investigated way. I did not investigate that yet. I didn't look at it. So now giving you an answer like this would be irresponsible. At first sight, it's very difficult. I do not see in the list so easily, but I did not think about it. So now giving you an answer on that, I would not be responsible. We have prepared this for 2 years working on the Turkey Tribunal and 1.5 years on this communication. We have put all the effort to be as detailed. We were very critical about ourselves. And I think when you act and busy with crimes against humanity, you should say nothing light. So my answer would be too light. I will not give you an answer on that.
I'm an investigative journalist. Maybe will be some, repeating things. I'm sorry for that, but I will try to understand that it is many thousand, crimes against humanity in Turkey. How many of them, how many thousand or how many of them is submitted to the ICC now? How many to the International Human Rights Court and the European International Court, European Human Rights Court? How many cases? And who is, maybe would be again repeating, who is, which person or which institution are responsible for those cases? Okay. The person and the institutions.
No. We have submitted the crimes of more than 200,000 persons, more than 200,000 victims. We have submitted. But when you submit it, that does not want to say that the court can go to a procedure of individual responsibility about this 200,000. You need a global attack, and then you can say, and for this cases, there we go for the individual criminal procedure. So more than 200,000 victims are concerned, and the individual cases that we submit for individual is 1,300 victims. 1,300, 1,300 victims that can still grow if other peoples would. Excuse me? In ICC, but the 200,000 also introduced to ICC. But that is the context for the attack. You have to prove the attack. The individual cases are 1,300 as for now, because during the investigation, of course, that can change. You asked how many complaints were introduced to the European Court. I think it's around 20,000, but I'm not sure. European Court of Human Rights, I think it's about 20,000 complaints that were introduced, but I'm not sure. It's the number, but it's huge. We went to the European Court for a grand chamber a month ago, and then they were saying there were still more than 10,000 pending. So there is a lot of them. A lot of them are there. And we have the United Nations Working Group on Enforced Disappearance. I think there's some 20 cases that have been discussed for the United Nations Working Group also. 20, yeah. But you see that all these figures are completely an evolution, of course, as the crimes are still being committed. Yeah, you have the United Nations Human Rights Committee, I think 2 or 3 decisions. I don't know how many cases, 2 or 3. One was introduced by us, 2 by other lawyers, but I think 2 or 3 decisions that are made. They call that advisory decisions, but I don't know how many cases were submitted, but decisions are made, yes. Human Rights Committee of the United Nations Human Rights Committee, yeah.
United Nations Human Rights Council now.
Yeah. No. No, committee. The council is something that was before you had the commission, it's now council, and the committee is a kind of a judge, committee. And there are at least 2, I think 3 decisions, but I'm not completely sure.
Any further questions at this point?
Which national institutions?
Institutions are not concerned. This is a criminal case. The International criminal court is not judging institutions nor companies. They are judging persons. Persons. That's the big difference with the European Court, for instance, where the state is condemned. The International Criminal Court cannot judge a state, cannot judge an institution, cannot judge a company. They only can judge persons.
In this case, will be Erdogan and the European ministers.
I already answered that. I cannot answer that. It's the officials, administrative and political, who they decide, but it's persons. And that means also they have to prove that they were responsible for it, that they knew it, that they were deliberately, as for every criminal procedure. You have the facts and you have the element, the moral element. You have the fact, for instance, you kill someone, and the moral element that you wanted to kill. If you let fall something and sometime died, it will not be the crime of murder. You have the fact and the moral element to will what you wanted to do.